number 70, Cayuga Nation versus Campbell. Good afternoon, Counsel.
May it please the Court, I'd like to reserve 3 minutes for rebuttal.
Of course.
My name is Margaret Murphy. I'm here representing the appellants who are defendants in this action. This action was commenced by 5 individuals who claim to be the lawful governing body of the Cayuga Nation. I'm going to refer to that group as the Halftown Group, and I'm going to refer to my clients as the Jacobs Group. Now, the Halftown Group, I think it's notable and important for the record that none of these individuals are chiefs, condoned chiefs. It is also important to note that by the Halftown Group's own admission, 2 of its members do not qualify to serve on the nation's council because they have not been selected.
Well, so that's the continued dispute. So
Yes.
it seems to me the question is whether or not the decision below to defer to what appears to be a federal determination of who represents the nation is the question before us. Not anything about your dispute. There's obviously a dispute.
Right.
So why, in your opinion, right, are the courts wrong to have deferred to that federal determination?
Well, I think to refer to the BIA decision is you have to recognize the BIA is not given the right by their own admission to arbitrate those types of dispute.
Well, for certain purposes, they are allowed to make a determination as to who to recognize, correct?
Absolutely.
And how, for example, would you distinguish this case from the determination in Tanner and in the Timbisha case? What's the difference?
Well, in Tanner, you had a situation where someone, in fact, the Halftown Group, brought an action, but not against its own members, or not by members of its own council. They brought it against a village, challenging whether that village had the right to impose an ordinance regarding bingo in that village. So there you don't have a dispute between the leadership within the council.
What you're saying is that the court didn't have to determine whether one party had the right to bring the action. That wasn't used to determine the merits of the action itself.
That's right. It did not determine the merits, only the standing of the party to bring the issue to the court.
Yeah, but deciding standing is deciding who gets to make choices in that litigation, which may very well implicate who represents the nation.
Well, I think you should put, in Tanner, the Second Circuit made it very, very clear that they knew of the dispute and said by allowing the Halftown Group to bring the action was not in any way their view of whether or not they are the governing body or to support it or even to dispute it.
No, I understand. I'm asking you about the getting behind that characterization, getting to the logic. When one decides that someone has standing, they can proceed, they're going to make decisions about how that litigation is going to move forward, and isn't that, in some level, implicating whether or not you're representing the nation as you make those decisions? Because only the nation can do that. Or is your position that was wholly external to the nation, that action?
Yeah, well, the whole thing is whether or not a village in the state of New York has any jurisdiction to pass laws against a tribal nation is a more neutral question. Now, what could have happened is...
But the outcome may very well impact the nation, right?
Not necessarily, Your Honor. Why it may be that, and even our clients would contend, that the village did not have the right to pass laws that could be imposed against them. The question of whether to have bingo operation at a facility operated by the nation, that's an internal governance matter that still needs to be, which can be resolved within the nation and is not subject to a state court or even the federal government's decision as to how they render their power.
But to go back to, I think, Judge Rivera's point. I read Tanner to say somebody has to be able to come in and represent the nation here. Judiciary, we're not going to do it. We're going to defer to the executive branch. We'll look at the record. Best evidence of the record here is this BIA decision, which now has been confirmed right in D.C. And that gets you, not so much standing, they said, but you can initiate the lawsuit because standing is the nation itself. And so here we have a property dispute. And the initial question under Tanner is, can this group bring the action as the representative of the nation? Because it's a property dispute where there's no dispute over the owner. The owner is the nation.
That's right.
So going back to Judge Rivera's point, once you get in the courthouse door and you are the representative of the nation, the court doesn't have to, I think in the perspective of what we're looking at in the appeal, say who wins that internal fight. All they're saying is, okay, you as representing the nation are saying these people don't belong on this land, they're trespassing. I'm saying that on behalf of the nation. Or, in one count here, these people who are operating the businesses, leaders, not leaders, whoever they are misappropriating funds, and this is a count, for their own personal use. Why do they have to get into who wins the internal dispute to resolve that count?
Well, Your Honor, you're really going beyond the record, but more importantly...
That's a count in the complaint.
No.
It's not in the record.
We didn't bring the complaint. The complaint is brought.
Right.
And going to the merits of the complaint, you have to look to the claims. That's why I think you need to look at what the dissent
But one
said.
charge here in their complaint on behalf of the nation
Right.
is that the people who are operating these businesses are diverting the money for their own personal use. Why do you have to get into who is the natural leader of the nation to determine that count?
Well, and the Jacob Council, in the reverse, believes that the Halftown Group is doing the same thing. The question becomes, and I see I have
But even if these people have some claim on leadership, if they're diverting the money from this and putting it in an account in Switzerland, let's say, in this hypothetical, of course, why can't the court determine that on
That's-
behalf of the nation?
Except that's not the claims that they brought in their complaint. They brought claims of trespass and ejectment. They bring it against old chiefs and clan mothers and clan representatives who serve on the council.
So there's not a conversion claim in there.
There is a conversion claim. In fact, it's right in their claim. They call it conversion, trespass, interference with business opportunities.
It's a conversion. Your argument is, well, yeah, they're arguing conversion because they're saying that the Jacobs Council, using your term, is not the appropriate representative, and therefore everything that they do with this property is for themselves, not the nation. Is that what you're trying to argue?
Well, that's the claim of the Halftown Group. We aren't, that's not our claim. The bottom line is
I didn't say it was your claim. I thought you were trying to explain why it still requires that you look at at the underlying dispute, right? That you're saying that, in essence, what they're really arguing when they say conversion is that it's because the Jacob Council doesn't have authority, and that's why it's conversion.
Well, that's exactly what the dissent looked at in the Fourth Department. They said each of these claims would require the individual defendants just to have to explain where their authority comes from, what their justification.
They would have to have a superior right.
Right, but this is the important thing that I think this court is ignoring. What is the impact of this decision? The impact of the decision is to tell members of clan mothers, chiefs, and certain citizens of the nation that they're enjoined from entering a longhouse. The longhouse is where they conduct business of the government, where the clans meet to reach consensus during a deliberative thing.
So let me ask you this. If I myself moved in intervention, filed a complaint in intervention in this lawsuit, saying that I was the lawful representative, could the court throw me out, find some facts that I actually have no relation to the Cayuga Nation, and throw me out?
No, the courts have no ability.
The court could not throw me out, throw my complaint out.
Not if there has been some recognition, which the BIA has recognized, and they have admitted that if you're a condole chief, if you're a clan mother, that is not in dispute. We know that two members who I represent are condole chiefs, are clan mothers. That was recognized by the BIA, that has been recognized by the Halftown. The problem is that this dispute that has been going on since 2004, they claim has now been resolved because of what they have called the statements signed by citizens. Citizens who, if I went out and took one of your decisions, this court's decision, and got 60% of the registered voters in New York State, they can't reverse the decision of this court.
But you don't question the BIA's authority to make that determination for purposes of government-to-government transactions, do you?
When there is a federal purpose, and in this case, the federal purpose is to give federal money.
Okay.
They can flip a coin.
So the question is whether, when and whether when that determination is binding on the courts.
Right. It is binding in that you have to give deference to it. That is the issue.
Right.
And if you look at the BIA's decision, as they said, that it has a broader implication that you need to give deference. But I would say that is contrary to the bedrock principle that the BIA itself, with the Interior Board of Indian Appeals, that is an adjudicatory agency within the BIA, who basically would say that bedrock principle constrains what the meaning of their decisions
Didn't the
are.
circuit address this issue on the limiting language of the BIA decision, same one, and said, true, but we're not using it for that purpose. All we're using that decision for is an evidence of the executive branch's view of who represents the nation. And they used that to say who could initiate the lawsuit. That's all they did with the BIA decision in face of the exact same argument that was it's only limited to contract nation, to, federal government to nation interactions. So what they were using that for was the purpose of saying, what is the executive branch's view of who represents in order to initiate a federal lawsuit? And then they allowed them to represent the nation in the federal lawsuit in Tanner. That's how I read Tanner.
Okay. Well, okay. Tanner, as I said, only went to the issue of what rights the nation has against a village. It doesn't describe what are the rights
But it's
that
not
this group
couched in
has
that
against other
language.
members of the council.
It's not couched in that language. It goes to who has the right to bring an action on behalf of the nation. It doesn't speak to who the respondent is in that action. Certainly, there would be the case where you have, a third-party trespasser here, where the nation would have an interest in coming in an eviction proceeding. But you also have a case where they're alleging that funds are being diverted from their proper use on behalf of the nation. So the same types of concerns govern that there may be waste, there may be fraud, and I'm not judging the merits here, and there's no venue to do that. There's no one to represent the nation's interests, and that's what they were looking for there, which seems to me very similar to what we would be looking for here in a case involving state property, right? This is property outside the reservation. It's land that's governed by the rules and regulations of the state, which Tanner and City of Sherrill have instructed. So, in terms of zoning, in terms of taxing. You don't agree in terms of zoning, in terms of taxing. That has already been decided in this case?
The bottom line is, this is about dominion and control of that land that is owned by the Cayuga Nation. And in that regards, this land is located in their ancestral land, which the Congress has not disestablished this reservation, has in no way. And this court in Gould recognized that. More importantly, you're forgetting the footnote in the Second Circuit, like it has no meaning. The Second Circuit made it very clear that the half-town group, they did not support, or did they oppose, or felt it relevant, whether they are, in fact, the lawful governing body of the nation itself.
Okay, so given the BIA decision saying that moving forward,
Right.
if this dispute continues, that's for the nation to decide what, if any, meaning the decision with respect to that survey will have moving forward.
Yes.
So what is the Jacob Council's view as to how they would resolve this dispute, to establish for the BIA that the half-town council is not the appropriate representative of the nation? How would you show that now?
How do we show how to use?
Yes, because you've taken the position, Jacob Council's taken the position that what the BIA permitted is not permissible under the law, under their law,
That's right.
right? So what is the position of the Jacob Council moving forward?
And moving forward, the Jacob Council says this has to be done on a consensual basis with all claimed representative being present in the Longhouse. It is supposed to not be by a mail-in survey. It is supposed to be by a process of listening, questioning, and debating the issues.
So
And then
if the impasse continues,
Right.
does that mean that it strikes me that then you're stuck with the prior BIA decision if your impasse continues?
No, no, because as the BIA has said, going forward, the meaning of this statement of support is a matter of Cayuga law, and which the BIA said previously in the matter of George versus Eastern.
Yes, which you both dispute, and the BIA held against you on that.
For purposes of deciding who was going to get this federal money. But
And you mean it stops there?
Excuse me?
You mean it stops there?
And it stops there.
With those
Only for-
grants, now it's done, you're back to your impasse.
Back to the impact, because as the Internal Board of Indian Affairs said in George versus Eastern Regional, versus the Eastern Regional Director, the BIA has no authority to serve as an arbitrator for tribal disputes or for the convenience of agencies or third parties.
Thank you, counsel.
Thank you.
Counsel?
Thank you, Your Honor. May it please the court, my name is David DeBruin. I'm counsel for the plaintiff, the Cayuga Nation, which, as the court recognizes, is the undisputed owner.
Counsel, has the BIA or anybody else in this process here said anything about the property rights at issue in this particular action?
No, it has not, Your Honor, nor would the BIA ever have reason or occasion to do that.
Well, that's a good question. I mean, it seems to me that in Timbisha, there was a much broader statement of authority. What about, there's a pending trust application. Could that lead to a broader determination?
Well, Your Honor, the BIA in its decision recognized the pending trust application. It recognized other government-to-government matters. And what the BIA concluded in unequivocal terms is that we recognize the Halftown Group as the proper government of the nation as determined by the nation's citizens.
Well, but what, as I read it is that we have to make some determination for who to deal with on a government-to-government basis. And for that purpose, we're looking to all these facts, and for that limited purpose, that gives us something to rest our hat on. We'll rest our hat on that, and at least now we know who to send this money to. I really read this as the BIA recognizing its own limitations and exercising those limitations explicitly in this action. And I'm not saying that there couldn't be situations in which they could make a broader statement, but I just don't see how that happened here.
Your Honor, as the court in Tanner recognized, the federal government, the federal government has the responsibility for resolving all matters of Indian affairs. And in doing so, it has a responsibility to recognize the government of a nation that it will interact with on a government-to-government basis.
But in Tanner, it had again, it sort of looked to, okay, here is an issue about gaming that involves a village. The underlying issue was not about the leadership dispute. And so the court said, okay, we have to, again, look to something so that somebody can come in here and represent the nation as against a third party. And I think those concerns are very legitimate. Somebody has to do it for those, but it was limited to that, and that's not the situation.
Well, it is the situation here. Tanner involved the nation's right to assert its rights over its property and how that property would be used. The third party in that case
But the
happened to be the
question
village.
is
There are
who's
third
it?
parties in this case, Your Honor, and their claim that they are the leaders is a claim that a dispute that existed for more than a decade, and the BIA and the courts, Justice Bender, the Supreme Court justice in this case, urged the nation to resolve that dispute. And after more than a decade, the dispute was submitted to the Cayuga people because the nation lost all of its land until recently when it reacquired it. Its people are scattered throughout the United
Even here,
States.
they expressed concern about that process, and
But, Your
maybe
Honor,
I'm just repeating
ultimately-
myself, but I think that they were very careful to say, we need to do this because we need to deal with them on this issue. We're not going beyond that. And
that-
so
Your Honor, that is how the federal government always acts. And I would urge you.
Counsel, doesn't that mean that if tomorrow there was a grant due, and there were two competing grants, one from the Halftown faction, one from the Jacobs Council faction, that the federal government's going to have to go through this process again and decide, okay, how do we figure out? Because they've already got a precedent where they don't necessarily accept who in the past has been the recognized representative when there is a dispute and I don't want to call it a competitor, but a faction that argues that not only are they the representative, but that Halftown is not the representative.
But, Your Honor, there is no evidence in the record that anything has changed.
No, but just answer that question. Would the BIA have to go through that same process again,
Well,
given what it has said in these decisions?
not because of what it says in the decisions. It always could be called upon to make an assessment of whether there's been a change in the nation's government. The nation has that right. The BIA recognized that it could make a change. There's been no allegations that anything has changed
Here's
from the
my question
nation's
then.
resolution
How
of it.
could, given the impasse, which is it's reflecting a philosophical difference in the way you view governance, given this impasse, how could the Jacobs Council ever satisfy the BIA on this issue? Their position is you simply cannot proceed through majoritarian elections. That's not how we function.
Your Honor,
How
that
do you
issue,
get past that is what I'm asking
that
you.
issue was submitted, it's not to the BIA. That issue was submitted to the Cayuga people. The very arguments that Ms. Murphy
Yes, but
made
this
today.
is my problem with your argument. Jacobs Council continues to dispute it, but I'm having the same challenge, I think, that Judge Stein is having, perhaps for a different reason, regarding what the BIA is saying related to that process. They have made clear that they're not wedded to this process in the future. They've made clear that there could be an alternative process by which the nation speaks. Jacobs Council has said, this is what we propose as the way we speak. Obviously, your side is
But
proposing
of
a
course,
different
what
way.
you are suggesting is gridlock, that there is no way a nation
Yes,
can ever.
I am.
Well, and so what gridlock means is what you're saying is if the courts of New York,
Yes.
the Halftown Council has come to the courts of New York repeatedly to try to enforce the rights of the nation. These are nation properties that are currently being possessed by who knows who is operating that store that generated $5 million of revenue that the nation distributed to its people and lost in 2014.
But you're not suggesting that they're not members of the nation, are you?
I'm suggesting we don't know who they are, who is in
You
possession.
don't have any reason to believe that they're not members of the nation.
There's
That
nothing in the
This is not
record.
an internal dispute.
Yes, we do dispute who currently is in possession of the store. That is a factual issue. All I'm saying is the nation has the right to possession. It is the nation that is the plaintiff.
What is it?
The
what is
point
it-
is, how do the people resolve this?
The issue,
This
that's,
just-
the whole point is that is the underlying merits issue of the action is who is the nation. I don't think it's disputed
the
that the
point, Your
nation
Honor,
owns the property.
I appreciate that. If you're saying the courts are closed, the Cayuga Nation must resolve this for itself. Law and order is gone, and whoever has the bigger stick will take the property.
But that's not
That
law and
is
order,
what you're
that's
saying.
the relationship, excuse me, that's the relationship between the sovereign people and the federal government and the
I
state government. We have
submit-
said, excuse me, that bedrock principle, that's the language in the cases, that the courts cannot resolve these disputes. You may argue that this is actually not a dispute that the courts would resolve, but if we think it is a dispute, that's the precedent.
That is not. I direct you to the Russian socialist case of this court involving foreign sovereigns. And it's no different for foreign sovereigns than for Indian sovereigns. And in that case, the dispute was who had the right to possession of the Russian consulate or embassy in New York, property in New York, following the Russian takeover. This is in 1923.
About Section 233.
Yes.
What, if anything, does Section 233 authorize the New York courts to do that, for example, the New Jersey courts are not able to do?
Clearly, Section 233, along with New York Indian Law Section 5 and Section 11A, all were designed to expand and make clear that New York courts have jurisdiction to hear claims involving Indians, involving Indian nations, and even to apply Indian law. Clearly, it is an expansion. But I submit you don't need even to rely on those statutes to reach the fundamental question. Again, I asked the court, who have asked me questions, how did the Cayuga people ever resolve anything? Here, the Jacobs group doesn't like the campaign that was used to reach out to all members. There could be an election.
Let's take your example of a foreign nation. Let's say France can't figure out its government. Let's just say that for one moment. The United States can't make a decision about who controls, right? Unless it's got a particular limited issue that our law permits us to decide.
What this court said in Russian Socialist, this is in 1923, quote, "It is not for the courts to say whether the present governments of Russia or Mexico or Great Britain should or should not be recognized. They are or they are not. That is as far as we may inquire. It is not for this court to decide whether the BIA properly or mistakenly recognized the Halftown Council as the government of the nation chosen by the Cayuga people."
No, but the question is whether or not that BIA decision was limited to the purposes before it, i.e. resolving the competing grants presented.
I would direct you to Respondent's Appendix 34, RA 34, where the BIA concludes, this is the decision of the Assistant Secretary, the final decision of the federal government, quote, "I therefore affirm the regional director's decision to recognize the Halftown Council as the legitimate Cayuga Nation government and to reject Appellant's 638 proposal as unauthorized." The point is the BIA, called upon by the 638 contract to recognize a government, has recognized a government. That hasn't changed. That was affirmed by the D.C. courts in 2019.
That may be an argument. I don't think it's your strongest argument. I read Tanner again to say the only reason we're going to look to that BIA decision is to see who can come into this courthouse. We need somebody to vindicate the rights of the nation. Who can come into this courthouse and represent the nation in this litigation? They look to that as the best evidence of the executive branch's recognition of somebody to be able to do that. They said it's you. And you got through the courthouse door. You could initiate the litigation there. Not standing because it's the nation that really is the primary party, and the nation is vindicating here its rights. So I think there's two questions. I think on question one, it seems to me, if you adopt the Tanner approach, that's over. BIA recognition, executive branch, you get to initiate litigation. The next question becomes, and I think what Judge Stein was getting at is, okay, but in order to determine the subject matter of this litigation, do we have to resolve your internal dispute over who the leadership is? And my question would be, what if a member of your council was on this land and was taking the money and sending it over to a Swiss bank account? And the council came in and said, you're stealing the money, this is a conversion count, we're representing the nation. Would the court have to throw up its hands and say, well, that may be a legitimate part of your leadership, and that defendant says, no, I'm part of the leadership? Wouldn't the council, as the representative of the nation, have the right to enforce the property rights related to the property in the nation's name. And that's what the first part gets you, and it almost gets you the answer, and I think what the courts below did, it gets you the answer to the substantive question here, because of the nature of the rights that are being enforced on behalf of the property.
I agree fully. These are properties of the nation. What is at issue? And we're here on a preliminary injunction that simply ordered possession of the properties to the
I
nation.
thought you were here on a motion to dismiss.
No. We are here because Justice Bender issued a preliminary injunction simply ordering that the nation,
But I thought the
through the
same order
recognized
also
government,
denied
is,
the motion to dismiss.
Yeah.
well, yes, but,
And if the motion to dismiss, yeah,
Is what they appealed.
right, yeah.
well, yes, they said
That's what's here.
the court had no jurisdiction to issue the injunction, but all I'm saying is the court has not adjudicated all of the claims. And so I agree with
The question
you.
before us is, can the court adjudicate the claims, and if so?
It clearly can adjudicate, as Justice Bender found, he can adjudicate some of the claims, including the basic right. Does the nation have the right to possess its own property through the government its people have chosen in a process that the BIA has recognized? Nobody disputes that. The second question is, he recognized there are certain claims going back to 2014, before the people made the choice of government, before the BIA recognized that choice by the people. Would there be potentially sovereign immunity for some claims at some time by some persons? And Justice Bender said, that's not before me yet. All I'm deciding is, A, I have subject matter jurisdiction. I can hear this case. I can recognize the plaintiff as the Cayuga Nation is represented in this case. Claim is brought by the rightful government that the BIA recognizes. I don't have to decide that recognition. That's what the BIA decided.
I'm just a little confused in this, because and you'll help me understand this, as I understand it, the federal government can only make these determinations for the immediate purpose before it. It sounds like you're arguing that the federal government was not merely deciding, okay, who of these competing factions for these grants is the representative of the nation, but rather decided the larger question, which is at the heart of the impasse: who represents the nation writ large? I'm just not sure that is the kind of decision the BIA can make, right?
Your Honor,
When it's presented with competing grant requests, that's all that's before it.
When presented with competing grant requests, it had to
It's
make
got
a
to decide
decision.
for that purpose.
Well, that's what triggered the decision, but the question
But
before
for
the...
that purpose, you want to say
Yes.
yes, and when they did that, that meant they're deciding for all the
Your Honor, I
future
direct you to
who represents the nation for other purposes, and that's where I'm having a little difficulty.
I direct you to what the BIA concluded and what the Assistant Secretary concluded, that the dispute that had existed for more than a decade had been resolved by the tribe through a tribal mechanism that was consistent with Cayuga law, and that the federal government would recognize that resolution. Nothing has changed since the tribe resolved that dispute.
So let me ask you this: if there weren't these competing grant proposals that trigger this, could you just have said, we're at impasse, just decide this? We can't. You've been trying to help us negotiate it for we can't. Just decide it. Could the BIA have done it at that point?
No, we don't contend that they could, and that's certainly not what they did.
So then how could they if the only trigger is a limited one?
Well, the federal government has a general responsibility as the guardian of Indian nations to identify who it will recognize for government-to-government interactions.
For its purpose.
There is virtually always some entity, some federal representative that the federal government recognizes, because there are myriad federal grant programs, other interactions that go on all the time, just like with foreign governments.
So where's the government-to-government purpose in the action that has been brought with regard to this property?
Well, the government-to-government is the Cayuga Nation has come to the government of New York, the state of New York, the court system of New York, to protect its property rights like any other property owner.
That's begging the question, but, okay.
Thank you,
The
Counsel.
federal government is not involved in this dispute. I don't claim that it is. But the point that matters is the federal government has recognized the Half-Town Council as the rightful government chosen by the people. Just as when the federal government refused to recognize Russia, it had nothing to do with the property dispute in New York. It had to do with trade and treaties. That's what the federal government caused them to recognize or not recognize Russia. But then this court, in resolving a property dispute that had nothing to do with the federal government, said our sole job is to ask the question, who does the federal executive recognize vis-a-vis this foreign sovereign? And that's exactly what we have here.
Thank you, counsel. Thank you. Counsel?
I want to address the issue about Section 233. It gave jurisdiction to state court to resolve private disputes, not disputes that would involve members who are condoled chiefs or clan mothers. I also would like to point out what the BIA decision and
Well, why do you say that? The words of the statute don't say that.
No, but the decisions of this court has found that, and the decision of other state courts have found that. I've cited a whole
Well, there
list
can't
of
be decisions of other state courts about Section 233.
No. Courts in New York have determined that. The Fourth Department determined that in Seneca versus Seneca. This court determined it in the St. Regis Mohawk cases versus in a footnote. It has been decided by the Third Department and the Fourth Department, and I've cited those cases in my brief, where the purposes of 233 is limited to private disputes, private disputes, and not disputes that would involve members of a tribal government, including condoled chiefs and clan mothers.
Wasn't part of, and I'm not saying it applies here, but wasn't part of the genesis of 233, the impetus for it was that there were no tribal courts in certain circumstances to resolve some of these disputes.
Disputes that would arise,
Whatever type of disputes, but there were no tribal courts to resolve them.
that would allow non-Indians to get,
But they're-
to resolve their disputes.
Actually, I thought the statute covers Indians and Indians, not Indians and non.
Indians and non-Indians.
Only Indians and non-Indians.
No, Indians and Indians and Indians and non-Indians.
Right, both.
Right.
Okay.
And that, so that
And
they
there are
can
no
have,
tribal courts here that are going to resolve this dispute.
to resolve private disputes.
But there's no tribal court in this case that is going to resolve your leadership dispute, right?
No, it's going to be resolved as what it should be.
So now you have a piece of property that could be in downtown Manhattan that's owned by a nation. And there may be people, it couldn't be. This is just purchase on the open market. It's an investment. And it could be that one group controls it. It may get somewhat violent. I'm not saying this is this case. It's a hypothetical. Another group comes in, spills into court. Who's the rightful possessor of this case? And New York's going to throw up its hands and say, you know what? I could dispute over leadership. Shoot it out. You know, fight it out over there.
The distinction, Your Honor, is the difference between on-reservation property and off-reservation property.
But this is
And
not
it's-
reservation property. This was
Well,
purchased
then
on
you-
the open market.
Then I will indicate to you that this, then, in all due respect, this court needs to go back and reread the Gould decision, which was rendered by this court. This property is located in the ancestral lands of the Cayuga Nation.
So I just want to be sure. So your position is if this land is not reservation land, you lose?
Well, and the only person who can decide this is not reservation land is Congress, because this is part of the original treaties that predate the Constitution.
I didn't ask you that.
Well, I guess the question becomes who decides whether this
I
is
didn't ask you that. I
reservation
said
land.
if. Assume it is. If,
Okay.
then what? You
Yes,
lose?
if this was off-reservation land, we'd have a whole different argument
Well, I
here.
didn't ask you that either.
Huh? Excuse
Do
me?
you lose if it's off reservation land? If it's in the middle of Manhattan?
Yes, absolutely, we
that's all-
lose.
yep.
That's
But
all
how
we
do you
need.
square that position with the town of Sherrill? The Supreme Court decision where they were buying ancestral lands and seeking to make kind of a patchwork nation, and the Supreme Court said you can't do that. This land has been on the public, you know, in the market in part of a town for 100 years.
That is still reservation land, but because there's an abandonment period, the court in Sherrill indicated, the Supreme Court is saying that that does not displace the rights for a long time that local counties and towns had in regulating that
But
land.
essentially, it said you
However,
can't repatriate that land.
that's not what it said. It didn't say repatriate that land. It
It's not
basically,
considered part of the reservation in Sherrill.
once again, those things are still being disputed because that is still, Congress has not disestablished the lands here in Cayuga or the lands that's represented by the United Nation. But, Your Honor, I see my time's up, but I have been desperately trying to hit a couple of points that I have not been able to reach. So if you could just give me indulgence so I could just
I will indulge you. You have another 2 minutes. Go ahead.
Thank you very much. The BIA decision was for a limited purpose. But if you read that BIA decision, it did not say anything about ousting condolence chiefs or clan mothers. It did not prevent them from going into a building which is used for longhouse purposes so they can participate in the government, or any citizen for that matter. It did not say that my clients, condole chiefs, clans, and clan representative had no culpable claim to claim that they could manage the affair of the nations or individually had unlawfully acted on behalf of the nation in overseeing what they saw as their obligation. Most importantly, as I've indicated, the Internal Bureau of Indian Appeals has, as they keep talking about the Russian government, there is no Bureau of Russian Affairs in the United States. There is a Bureau of Indian Affairs, and part of that bureau contains the Internal Bureau of Indian Appeals, an adjudicatory body that has made it very, very clear on multiple occasions that the principle of tribal sovereignty and self-determination serves to constrain the BIA's intrusion into internal government matters. And therefore, unless it's truly necessary to satisfy some separate federal obligation, they're not to be the arbitrators of who is in this council and who is not. And that is precisely what the Half Town Council is asking you to do.
Thank you, counsel.
Thank you.